All right, how's everyone doing? This is Professor Dan here, bringing you the latest installment of Professor Dan Presents videos for things that we would have talked about if we were having regular meetings, which we're not having because we're trying to stay safe, and things of that sort. With me, as always, is my trusty cameraman, the boy, back there sighing and breathing through his nose and making all kinds of faces at me from the other side of the camera. It's good times. So today we're going to be talking about the second reading from our family theme, and this is on the Supreme Court's marriage decision from 2015, which is usually referred to as the gay or same-sex marriage decision. So the Supreme Court ruled in 2015 that it was unconstitutional to have laws on the books that prohibited same-sex couples from getting legally married. So first of all, I want to say a real quick thing about the definition of legal marriage. Legal marriage means what the state recognizes as a marriage, not what any other particular custom or religion might recognize as a marriage. Any custom or religion can recognize anything it wants as a marriage. So, for example, there's a flavor of Christianity called Mormon, where in some of its variations they recognize polygamy. Islam also recognizes polygamy, and a lot of ancient religions recognize polygamy too. But the law does not recognize polygamy. So you can have somebody wave their hand over you and say, you are now married to 27 women, but it doesn't legally count for anything. So we're talking about legal marriage here. Now, the Supreme Court gave 4 reasons why it felt that the laws that prohibited same-sex marriage were unconstitutional and violated the 14th Amendment. One has to do with what we call autonomy. And autonomy basically means your personal freedom. Your ability to order your life as you see fit. Right? If you want to, and they had decided that this is a fundamental right that people have to follow their own personal freedom to order their life as they see fit. So when two opposite sex people wanted to get married, it had been ruled previously that any sort of law that would prohibit that based on race or religion or any other thing, those laws were unconstitutional, so this one had to be unconstitutional as well. The second thing that they talked about was the fact that marriage is what we call a unique kind of a union. What does that mean? Well, there are a lot of legal contracts that you can enter into with people, but marriage is unique insofar as it confers certain rights and privileges to people. For example, there are things like Social Security benefits. If you are legally married to somebody and that person dies, the surviving spouse inherits their Social Security benefits, right? So that's unique to marriage. I can't just have a contract. I can't just go to somebody and say, well, I like you, you're a great person, let me sign my Social Security benefits over to you. But if I'm married to somebody, they automatically get those benefits. Another one has to do with what we call end-of-life decisions. So if I get in an accident and I'm incapacitated, my spouse is entitled to make end-of-life decisions. Now, I could give that power to somebody, but I would have to fill out a lot of legal documents to do that, and it would be really prohibitive and difficult to do that, whereas the marriage contract is unique in that it automatically confers this, and it confers a great many other things as well. The third thing that they talked about had to do with children. So you may recall from the video that we did on Plato in the family, Plato felt that the guardians had a duty to the state to produce children. So the Supreme Court did not say that people have a duty to produce children. They did note, though, that if you were going to designate certain marriages as not protected by law and therefore outside the law, that would cause harm to the children of those marriages. They also noted that same-sex couples often face discrimination when they were trying to do things like adopt children, including their own actual children. This is something that people don't think about. But for example, if two women were married or were acting as married prior to this decision, and they had a child together via something like artificial insemination, in a lot of cases, the other spouse could not legally adopt that child because that union wasn't recognized, which means that next of kin rules might go in place, and if the birth mother died, that child might transfer to another relative as legal guardian. And so, for reasons of family stability, what we call family stability and identity, they decided that they had to overturn rules against these kinds of unions. And then the last one has to do with what we call social order. And this makes for an interesting contrast to what we talked about in Plato, right? In Plato, the marriage is for the purpose of society. The Supreme Court is saying that the marriage is a fundamental social ingredient or social unit. It's not for the purpose of society, but society is built on the marriages. And so to deny this to people who actually want to participate in it to strengthen the social order just doesn't actually make any good sense. So this is fundamentally what the Supreme Court decision is about. Now, for our purposes, in terms of how I want people to think about this for the upcoming paper, think about it this way. Rather than try to look at marriage as whether or not we want to talk about it from the perspective of same-sex couples or different-sex couples, think of it from the perspective of whether or not we want it to be a matter of individual choice and autonomy or something done completely in the service of others. And that's how we're going to talk about this topic. But that's it for today. This is how the Supreme Court decision works. And I hope everybody got something out of this. I look forward to making more videos when we get to our next topic. But for now, this is Professor Dan with the boy behind the camera, signing off. Have a great day, everyone.